There were two tests. One of them was just a screen, but the other one that's attached to the official record on appeal does have a lab report. And for the hearing officer to say, well, you didn't give me a verified lab report, that's just contradicted by the record. So based on this record, I would find that the hearing officer's decision reinstating the revoked license for Mr. Shona was an abuse of discretion and was not supported by competent material evidence on the whole record. Call Shona v. Secretary of State, file 26-9208AL. Counsel, you want to state your appearances beginning with petitioner.
Luke Custody on behalf of the petitioner, Your Honor.
Mr. Goodrich on behalf of the Secretary of State.
All right, and this is an appeal in a driver's license matter, and I've had an opportunity to review the petition for review, the record below, as well as your brief in support of the petition. Mr. Kukuski, go ahead and make any argument you wish.
Thank you, Your Honor. Mr. Shona appeared before the Secretary of State seeking to have his restrictions removed that he had on his driver's license. Basically, the restriction, it was a curfew restriction that he had left on his driver's license. He had been revoked back in 2004, the restrictions that he received after the revocation, the year of revocation, were that he had the interlock in for a year, and then the, I guess, restrictions that associated with that. After a year of successful interlock, he did have that removed by the Secretary of State. He continued on the restrictions until the hearing he recently had to get those removed. At the hearing, the hearing officer found that not only was she going to keep on the restriction, but she was revoking his driver's license at that time. And so we're here to appeal that decision and ask the court for granting of his full license. The hearing officer made a few different findings to Mr. Shona to support, I guess, her reasoning why he should be back on the revocation. One was the interlock. There's no interlock report filed. When I did see an email that he had sent that should have made it into the record, why it wasn't, I'm not sure. I know that's not part of the record for Your Honor to decide, but her order in and of itself on the first page indicates that he was successful on the interlock. That's why it was removed. If you're not successful, that restriction is not going to be removed from you. And so, or his revocation would have been reinstated. It certainly would have, Your Honor. So I think that argument is without much merit. It certainly is, to me, an abuse of discretion. And then she went on to take issue with a statement that he made during the hearing, which asked about his sobriety. He says, working towards not drinking again. And so, in my experience with recovering alcoholics and dealing with the AA community, and I'm sure Your Honor is familiar as well, it's a lifelong process. It's a lifelong commitment. And so they don't talk as to, I'm never going to drink again. They say, you know, that's my goal. And I think even later in the hearing and in my brief, I put a statement that he had said that, yeah, I hope not to drink the rest of my life. And that's my goal, and that's what I'm hoping to maintain, my sobriety. So, again, I think that was a misplaced reason to revoke him again. There was also testimony as to marijuana use. He did have and testified that he had a medical marijuana card. It was prescribed to him. He was honest about his use. His last use was back in July of 24. That was disclosed to the assessing agent, who chose not to give any, I guess, status to his marijuana use. And so, again, it was a prescription that he had when the medical marijuana cards were. He didn't renew that prescription when it became legal. It was basically an over-the-counter prescription at that point, where his doctors, well, you can get it, you can get it. He no longer uses marijuana, and he doesn't have any intention to use marijuana, but certainly I think that was, again, an abuse of the discretion by the hearing officer. And the final and last thing was the drug screens. The hearing officer indicated that his drug screen had no variables on the drug screen. And in fact, if the court looks at the record that was provided with the transcript, Mr. Shona did provide two drug screens. One, he provided they emailed him right back and said, well, this doesn't look like it might meet the muster of the standard for the hearing officer. So he went and retested. Both tests negative for any substances, but the second one certainly did provide variables and would confirm that he was not using any drugs or alcohol because of the negative test that he received. Given his testimony, given the drug screens, his assessment, and just the totality of the information, and that he was there to remove the restrictions. He wasn't there as trying to get just a license or on restrictions. I do feel that the decision by the Secretary of State to reinstate his revocation was not supported by the substantial evidence on their whole record. It was just clearly an unwarranted abuse of the discretion of the hearing officer. So we're here today to ask the court to overturn that decision and to grant him a full license. Thank you.
Okay, thank you. Ms. Goodrich, the Secretary's position?
Oh, Your Honor, I'd ask that you find that there was not an abuse of discretion for the reasons given by the hearing officer in denying the request. One was for violating the restriction by using marijuana as recently as 2024. He did not have a marijuana card at that time. He also testified that he had been sober for 20-some years. Both of those things can't be true if he's using marijuana without a prescription. He also was not following, the second reason was that he was not following the recommendations of the substance abuse evaluation. The substance abuse evaluation was part of the court record, and the recommendation was that he continue community support groups. They provide essential emotional connection, accountability, and shared understanding, help reduce isolation and strengthen coping skills. He admitted to not attending support groups per that as recommended. The third reason was that the drug screen was not sufficient. And the fourth reason was he did not provide the interlock report. Thank you.
Well, thank you. Well, this court's review is, of course, for an appellate review. Not what I would have done, but did the Secretary of State hearing officer make a decision that was supported by competent material evidence on the whole record, or was the decision arbitrary, capricious, or an abuse of discretion? And in this case, the petitioner had a revoked license for a couple of drunk drivings a long time ago, and got a restricted license that at that time only had a 1-year interlock, successfully completed that interlock, and then was driving with the restriction for like 20 years. And then finally decides, I want to get rid of all restrictions, and goes to the Secretary of State to do that. He had the burden of proving by clear and convincing evidence that his substance abuse problems are under control and likely to remain under control. He presented evidence that he had abstained from alcohol for over 2 decades, supported by his community letters, submitted a substance abuse evaluation with a positive prognosis in not 1 but 2 drug screens. One of them looks like it was an instant screen at a doctor's office. And then the second one was a lab report through Redwood Toxicology, which is the same lab that this court uses as part of its treatment court supervision. And the petitioner disclosed to the hearing officer that he had a one-time, he had a use of marijuana in 2024. He didn't have a current medical marijuana card at that time. It wouldn't be a violation of law, but it would be a use of an intoxicating substance without any medical reason in 2024. That would be some basis for concern, and the hearing officer noted that, but the hearing officer said that that wouldn't be a reason to reinstate a revoked license And I agree with that statement because by statute, Mr. Shonath was only required to show 1 year of abstinence. He showed 20 years of abstinence from alcohol and, more than 1 year of abstinence from marijuana. From that, I guess it's fair to say on this record, it was an isolated use. So I don't think that isolated use overcomes the strong evidence of 20 plus years of alcohol sobriety. Further, the hearing officer found fault for the petitioner not submitting the interlock report. But the interlock report was from 20 years previous. The hearing officer I think it certainly is. If the hearing officer didn't have access to the report, the hearing officer could have easily obtained access to that report if there was any concerns, or could have continued the hearing to allow Mr. Shonath to provide it. Where the interlock was removed 20 years ago, and there's a notation on the record here that the hearing officer said there were no violations. And of course there weren't, or it would have been extended, or the revocation would have been reinstated. So that's sort of an abuse of discretion to say, I'm going to fault you for not giving me the 20-year-old report when everybody knows there would have been no violations, or you wouldn't be in the situation you're in. And plus, as a hearing officer, I can get access to it, or at a minimum, I could continue the hearing if I want to review it to give you a chance to get it for me. Didn't continue the hearing, didn't even continue the restrictions. Oh, and then also the hearing officer found fault with the drug test because it was only an instant screen. Well, the hearing officer is just mistaken about the record. There were 2 tests. One of them was just a screen, but the other one that's attached to the official record on appeal does have a lab report. And for the hearing officer to say, well, you didn't give me a verified lab report, that's just contradicted by the record. So based on this record, I would find that the hearing officer's decision reinstating the revoked license for Mr. Shonath was an abuse of discretion and was not supported by competent material evidence on the whole record. So therefore, I would grant the appeal and direct the Secretary of State to issue full driving privileges to Mr. Shonath. And Mr. Kukuski, you can submit an order to that effect.
I know this hearing was for later. I was going to go back to my office. My secretary said she did email the order, but that was something I was going to bring back. So
okay, great. Great. If we get the order, then we'll see if the prosecutor will approve it as to form. I think that helps things go more smoothly with the Secretary of State and get it signed.
Very good, Your Honor. Thank you, Your Honor.
Okay, thank you.
Thank you.
Good luck, Mr. Shonath.
Thank you, Your Honor.